It's finally verdict day. Deliberations began the prior evening with the jury requesting to view several videos. Court did not adjourn until after 8 p.m. So, of course, Brooks needs to make it clear to everyone that he is so exhausted due to lack of sleep. Welcome back, everyone. In this video, we will watch the reading of the verdict, the press conference following, the pre-sentencing hearing, and then I've thrown in a few extra items regarding the jury. So let's get to it.
Please. Morning, Your Honor. Sue Opper, Leslie Basie, Zach Wichow, all here for the state of Wisconsin. Thank you. And, sir, for your appearance this morning?
Just 1 second. I was certainly not in here. I'm not sure if I even have everything. I apologize for that, man.
It's all right. When you're ready.
I'm here as third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
He's such a drama queen.
Thank you. The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning. I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open, and the jurors are here, and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post, that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding, based on news reports, that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So,
go ahead.
So it's being called a prank?
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, the courtroom will remain open. I'm going to be working in my office on other things, and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties.
Judge.
Yes.
Go ahead.
No.
Go ahead.
I'm still very concerned about this whole Reddit thing after having the chance to fully read it and look at some of the language that's in it.
Oh, for Pete's sake, here we go.
It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like Your Honor to, if it pleases the court, and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the regards to the language, I also want to state that, for the record, this did not come about from the prosecution side, from the defensive side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
yeah. If it pleases Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial, and also any alternatives along those lines, short of that, or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion. And I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to the language is basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES. 917 F2D 388. And that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached, but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias, and I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language, it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options. Look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and
What's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
relief.
Relief.
And what are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue was put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room. They got certain feelings from where they specifically refer to themselves and a group. That would be we, plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is. clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, that this is clearly someone close to the case. And because of that, it still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks. And even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done. Something, and if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at.
I love how the prosecution is over there discussing something else, not even worried about what Brooks is saying.
If anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, now all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you, though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the Clerk of Court's office receive emails regarding this. It sounds like the district attorney received emails. I may have even gotten one. I don't remember the time. It was later regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it. And I simply forwarded that email on to law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record? That
your choice should be placed on the record. So
if not, I was offered to be in street clothes. If I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no. Do you dispute that you were given the choice this morning?
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if we were to challenge that you and claim that you are required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
All right. At this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record yet? And I object.
Nice try. Didn't work. Many people have commented that they wanted to know the outcome of this Reddit post investigation. They stated in court that the author of the post came forward and apologized, advising it was just supposed to be a joke. That's it. Nothing more than someone watching the trial trying to be funny. He or she was probably soiling themselves when this was addressed in the courtroom. I hope they got a good enough scare. Regardless, neither Brooks or any of his few supporters were behind it.
The record in State versus Brooks appearances are as they were before. I would make Just one note that Mr. Brooks is now present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter. And without anything further, I'll have the jury brought out.
Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record that has yet to be proven.
Your objections are noted. I will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Too late, Mary. Your fate is sealed.
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
The jury deliberated for approximately 3 hours and 15 minutes in total. But keep in mind, that included them filling out all of that paperwork for 76 counts.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. We will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor. Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor? For the record, may I request the legal or factual basis for your ruling, Your Honor?
It might have been a false alarm.
For the record, may I respectfully request a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor?
Oh, just ignore him.
Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant? You don't have to address admiralty law or common law if this court is operating under admiralty law?
I will not be addressing any of those issues.
Thank
you, everyone. Please be seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? Yes. All right, and I see it's juror number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
I bet they watched the videos the night before and had a unanimous guilty vote and then decide to sleep on it and complete the paperwork in the morning. She has to sort out and check all of these verdict forms, so I am going to trim this down a bit.
Your Honor, seeing as that we've reached a verdict, is it necessary that I have these shock devices on my ankles?
Ah, the Shocklets. They'll be addressing this in the pre-sentencing hearing.
confirm that there are 76 signed verdicts and 76 unsigned verdicts, which would be what I would expect. All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. Dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 13 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 16 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant guilty of first-degree recklessly endangering safety as charged in count 17 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 18 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 19 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 20 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 21 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 22 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 23 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 24 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 25 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 26 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 27 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 28 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 29 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 30 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 31 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 32 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 33 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 34 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 35 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 36 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 37 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 38 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 39 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 40 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 41 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 42 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 43 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 51 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 54 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 55 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 56 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 57 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 58 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 59 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 60 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 61 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 62 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 63 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 64 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 65 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 66 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 67 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. Did the accident involve death to Virginia Sorensen? Answer, yes. Dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information, dated today's date and signed by the foreperson. Mr. Brooks, would you like me to poll the jury?
Yes.
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first so it's a little bit easier. So juror number 11. Were the verdicts read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
The court is still satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please. Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. The court will also revoke bond. In this case, I plan on bringing the case in Monday, this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf, if so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon case.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That
You're welcome.
helps us in our planning.
All right. All right, then. Thank you, everyone. We are adjourned for today. We'll see you all on Monday.
So, what do you guys think? Did he know it was coming, or did he really expect to get a not guilty verdict? Let's go over to the press conference held after the verdict was read.
All right, thank you. Good afternoon, everyone. We're here to have a press conference to discuss some of the events that happened today. Speaking today will be District Attorney Sue Opper, Chief Dan Thompson of the Waukesha Police Department. Also, David Sorensen which was the husband of Virginia Ginny Sorensen, Tyler Pudliner, he's a Waukesha South band member, and Amber Conkey, a mother of one of the juvenile victims. Also present with us today is County Executive Paul Farrell, the prosecution team consisting of Leslie Basie, Zach Witchow, Detective Tom Casey from the Waukesha Police Department, Detective Ryan Rugland from the Waukesha Sheriff's Office, and paralegal Christy Giese. Also to my right, your left, is Jen Dunn and Carrie Peterson from the Waukesha County District Attorney Victim Witness, and with our comfort dog Pepper, who have played an integral role with our crime victims throughout this whole process. To that, Sue Opper.
Thank you. First and foremost, our thoughts and concerns remain with the victims involved in this tragedy and their families. Although the defendant devastated our community, the people of the city of Waukesha, Waukesha County, and beyond demonstrated tremendous resiliency. We are so grateful for the first responders, citizens, and medical professionals who sprang into action and immediately rendered aid and saved so many lives that day. We appreciate the jury for their work and dedication to justice. We commend the police officers and citizen witnesses who testified or were prepared to testify and asked to relive the events of that horrific day. We are satisfied that this defendant has been held accountable for his actions. He now faces imprisonment of 6 consecutive life sentences plus 859 years of confinement. There is much healing ahead for the victims and for our community, but we hope today's result is a step further along that path. Remain strong, Waukesha. Thank you.
Waukesha Police Chief Dan Thompson.
Thank you. 2 days we'll never forget. November 21 of 2021, on that tragic day, and October 26th of 2022. Why October 26th? Because justice was served today. I want to say thank you and praises to this community. I want to say thank you in the resiliency and strength of the families and victims who were involved in it and were impacted by this event. The investigation team, I want to send a personal thank you to the District Attorney's Office, Sue Opper, Leslie, Zach, and everyone on that team who assisted in this successful prosecution. I want to say thank you to the jury and the court process and the court proceedings and everyone that was involved in the court who found this defendant guilty, which is just and right. That defendant's actions did not define this great community. It refined us in our resolve and our strength in being Waukesha strong. Thank you.
Thank you, Chief. David.
I got it. Thank you. I'm David Sorensen. These are my 2 sons. Justice was served for my wife, Virginia Sorensen, my 3 children, and the whole Sorensen clan. Thank you very much to the people that did this court case. We appreciate it. Sean or Marshall wants to say one little thing.
We've been praying for this day for a long time, and this morning my 5-year-old daughter came up to me and handed me this necklace with my mom's ashes in it, and she told me to take my mom with us for the sentencing. So she was with us today, and I just want to thank everyone for what they did today. And one last thing, my mom always used to tell us when we were kids in our family that she always said, angels watch over you guys. So I just want to say angels watch over you guys and turn on those blue lights tonight.
Thank you.
I want to first thank the prosecution team. They were the one that got us to this point. I'm thankful for all their support along the way and getting us to this day. It's been a difficult day. I know that this will give us healing. This is another step forward in this process. We've been resilient all the way through. One of the things that I've said so much throughout this is that we're stronger than him, and it's been proven today. It's just another step forward in the process. So I want to thank Sue, Zach, Leslie, all those guys for their hard work, Jen and her staff, and especially those first responders. It's just been brought up. They are the ones that especially kept me here, gave us a second chance, and they've kept our community strong. So yeah, Waukesha strong. As Marshall said, he touched on it. Keep those blue lights on tonight. Thank you, everybody.
Amber.
Just want to say that I'm very happy with the verdicts and that, justice has been served today. I would just like to thank everybody, the first responders, the DA and the judge, all the law enforcement, everybody who was involved, especially those who were very much involved with my family and the support system that we have had. It's been amazing to see how wonderful this community has been to pull together for all of those who were hurt that night.
Thank you. With that, we'll take a few questions. Those available for questions will be Chief Thompson and District Attorney Sue Opper. So I'll start right here, TMJ4. Who would you like to direct your question to? Sue, come on up.
Okay, thank you.
Chief.
We just got to know, how are you and your team feeling right now about this outcome?
Well, it's obviously quite satisfying that Mr. Brooks has been found guilty and held accountable for his actions. As many of these victims have said, this is a joyous day for that reason. It's also the point where we hope everyone can move on from. The support that we've gotten as this case wore on day after day was tremendous, and we're very relieved. I guess that's the best word, is relief.
Hillary?
I saw you get a tear in your eye when they were talking about Virginia's ashes. You spoke about
Yep.
what this meant to you and the victims. How do you begin to describe what it was like going up against Brooks as defending him, representing himself? Did that change your strategy? How did you get through all that?
Yeah. I mean, legally it changed our strategy, certainly, because if there's an appeal, we have to do, he can make a mistake in the courtroom and get a new trial, and we have to pay the price for that, we the state and we the victims. So it's changed our strategy in that we had to make sure, and Judge Darrell did as well, the record was very thorough, very complete, and we didn't miss anything. But as far as handling the actual court proceedings, we felt very, very offended by his behavior, his disrespect of the court, the decorum, the families, his insulting the judge, his challenging the judge. That's not the way our system is designed. That was intentional on his part. We truly believe that. He did everything he can except claim that the dog ate his homework. And he tried to turn this into his story. Let's talk about Mr. Brooks and his family. And we just kept redirecting it back to the real focus here is our families, our victims, our community, and his responsibility for this destruction.
58.
What was the most challenging part, and how did you keep your patience through all of it?
Again, it wasn't a difficult case factually, and I don't mean to sound, overly confident in that, but this case was unique because the activity was videotaped, right? And so, whereas most cases we have to rely on eyewitness accounts or other ways to prove the case, we had videograph evidence of his behavior all up and down that crime scene and throughout the neighborhood. So that way, it wasn't difficult. Again, the difficulty and the challenges we faced was what nonsense was going to come out of his mouth next. And we were anticipating much of what would come next and being ready legally with case law and legal authority to be able to respond to that. So I think that was the hardest thing. The investigation was so thorough, so well done that we knew the facts were solid. It was just making sure the record and the presentation was done legally accurate.
We'll do Fox Local.
So what went into your decision to perhaps minimize the number of direct witnesses that went up on that stand? And I wonder, did you expect any of these antics, and if that went into your decision?
Yes, it did. So obviously we didn't know until very late that he'd be representing himself. But we as a team set out from day one, and this was months and months ago when he still had attorneys, we vowed we would not put children on the stand. Absolutely. It wasn't necessary. Again, there were plenty of other ways to tell this story without asking a child to testify in a courtroom and relive this very, very extreme tragic situation. So that was a commitment we made as a team months ago, and we stuck by that. Certainly, as we learned his antics, we reevaluated, and we would discuss it every night as a team: is who are we going to use tomorrow, and do we really need this person? Because we were so, again, not personally offended, but professionally offended that he would insult the process and insult the victims, accuse them of financial gain for their testimony, things like that. It was just so offensive that we definitely were conscious of that in our decision making, and how can we minimize this for the best of everyone, but still provide a compelling story. So yes, it did definitely play a factor.
Court TV.
Thank you so much. Ms. Offer, there were so many victims' families inside the courtroom every day, sitting behind you. How much did that motivate you and your team, and how you present your evidence and your closing argument? You mentioned them. And have you been able to speak to any of them that aren't here that maybe said something to you afterwards?
Yes. The motivation we received from those families was tremendous. And we knew, again, from the point when Mr. Brooks chose to represent himself, this was going to be a marathon. We talked about that many times as a team, that we just need to keep moving forward every day, whatever that looked like. But what motivated us was these families that are behind me, a lot of them. And we thought of those mothers and fathers sitting in hospital rooms with their children, and the ongoing care that they're still physically healing from and certainly emotionally healing from. And that motivated us tremendously. But you couldn't meet a nicer group of people. I mean, that's the thing, is I'm not surprised, having lived in Waukesha for 35 years, that they're good people here. And they would ask us, how are you doing? Do you guys need anything? Which was really phenomenal. They were a tremendous group of people to work for, and it was our honor to represent them and be a voice for them in the court.
Go ahead.
Andrew Brannick, Spectrum News. Yesterday it seemed you threw Darrell Brooks a little bit of a lifeline when it came to presenting his closing argument. It seemed that the judge was going to kind of forfeit his right to do that. What made you go that route to allow him and then just object to what he was saying?
That was strategic for the appeal, to be very blunt. I wasn't throwing a lifeline to Mr. Brooks. I really had no interest in hearing what he had to say, because I heard all of his lies and stories so far. So that was just trying to do what was legally required at the moment. And I frankly wasn't sure it was going to work, because he was so difficult with Judge Darrell. But in the end, it did work. He got to blurt out what he wanted to blurt, and then the judge struck that from the record, and we were able to move on. So I was glad that that was the result, but we talked about it at the prosecution table and came up with that idea of, let's offer this, again, just to protect the record for the appeal.
Jim.
Knowing what you knew going into this with Brooks representing himself, what caught you by surprise when he presented?
Again, his absolute disrespect and dishonor to the victims, the community, and the court process.
I'll do Brian from the Freeman, and then two more we'll do CBS, and then, where are you from? WBR. Okay. Those are the last three. So go, Brian, you got one?
There has been some discussion since the verdict was announced that perhaps a decision to represent himself is grounds for appeal. Are you concerned at all about that?
Well, Mr. Brooks has a right to an appeal. Every defendant does. And I fully expect him to take advantage of his rights as a convicted defendant in this case. I am very confident in the record that Judge Darrell made and his decision to represent himself. Yes.
Go ahead.
Hi, I'm Roxanne with CBS News. What do you think about the length of time that the jury took to deliberate? Short, long, are you surprised?
We were not. We talked about it last night, and frankly, I know a lot of you were here too. We were all, by the time we got to that 8 o'clock mark, we were exhausted. And when they said they wanted to go home and rest, we were thankful, quite frankly, because we all felt the same way. It's such an emotionally draining day. And to get through all that and the nonstop banter from Mr. Brooks, it's taxing. You all witnessed it yourself. So we were grateful. We thought they gave it good thought because they went out around 6:30. Their dinner was there immediately, right? So jurors are human beings. They get a nice meal. They got a little time to talk, and then they decided, let's rest. Let's sleep on it. Always a good option for decision making for anybody, right? Get a good night's sleep on it, and come back the next day. And then, they worked again for about another hour this morning. And with the quality of the investigation in this case, we think the verdict was fair. The timing was spot on.
Go ahead.
There's a lot of people who are here today, of course, but a lot of people who are also at the parade on the day of the parade who aren't here. In closing, what do you want to say to them just at the end of this process?
Well, I hope some of you caught the flavor of that. You cannot imagine until you saw some of those videos how horrific it would have been to stand there and watch that, especially when your children, and some of these witnesses testified to that, they couldn't find their children, right? And that's not just people who were struck. That there was many, many citizens who could not find their own child for a period of time. So just unbelievable. But once the car went through and everybody had that initial, the way the citizens of this community punched in, there's no other word for it. The nurses, the doctors, the EMTs, the paramedics, anybody who knew anything about how to apply a Band-Aid walked into that street and treated those people. So that was another source of strength for us, right? Is if they could do that, we can get through this.
Thank you. As we move on to the next phases of the judicial process, I'm sure that people will be readily available to provide comment as we get into. We have a court hearing on Monday at 1 o'clock, I believe, for scheduling, and I think then we're going to go into the sentencing phase, and we'll know more about that. People here behind me will make themselves available for you, I'm pretty much sure, as this goes on. But as of right now, we're going to end it and allow people to be with their families. And definitely this prosecution team needs some much-needed rest and some time away from this courthouse. So thank you all very much for being here today.
Thank you, guys.
If we could make a line so I can allow these people, thank you. It was more so at your camera.
Pepper and Jen were an amazing support for the victims. We'll be discussing more about them during the pre-sentencing. Now to the jury. The following are a few clips from a previous video uploaded.
Many of you have asked, when is the jury going to speak? Maybe they made a pact with each other that it just wasn't something that needed to be put out there. The trial already had way too much publicity. Well, one of the jurors did actually speak to some media, and it was part of a compilation that they had done. It was News 23.
Kind of like Groundhog Day, where every single day you go in and you repeat November 23rd. Once I realized the impact that this was going to have on the community, I kind of wanted to serve.
Waukesha parade murder suspect Darrell Brooks defended himself, which made it an incredible experience for Scott as juror number 6.
I didn't have any expectations, so, being my first time, this could have been normal, but you could tell it wasn't normal.
Jury out to argue with you.
They don't. The strange happenings began even before the trial did, when each side had 10 strikes to whittle the jury down to 12 plus 2 alternates.
He wanted to strike all 24 of us, and he ended up moving to a different courtroom, and they pulled out a bingo wheel and they just randomly selected 10 people for his strikes.
Scott, that Judge Jennifer Doro did a phenomenal job of keeping the courtroom in as much order as possible.
I felt bad for her because, you know, he just went rogue and did whatever he wanted and wasn't about to listen. And it was this power struggle.
The jury was sequestered during deliberations, which went about 3 hours over 2 days.
Everybody agreed. It was pretty straightforward to finally get into that deliberation room and finally getting to release the feelings that you have pent up over the last 4 or 5 weeks, to be able to actually talk about it. And that was a great relief.
So the free times, when they couldn't discuss the case, involved conversations about family, life dreams, and personal triumphs and tribulations.
We developed a lot of great bonds with a lot of inside jokes, and we have a little contact group, and we still keep in contact today.
Juror number 6 mentioned the jury selection process. As with most trials, that portion of the trial is not live streamed. Judge Doro had estimated 1 day to select the 16 jurors, 4 alternates, and 12 to sit on the panel to decide Darrell Brooks' fate.
The jury selection process began earlier this morning, though it's several hours behind schedule, as Brooks has refused to cooperate with the rules of the court.
It's been an incredibly busy and frustrating morning in court for all parties involved.
Brooks caused constant interruptions. First, he argued his constitutional rights were being violated. Then he argued that he had only 3 days to prepare for the trial. If you will remember in video 1, we sat through the questioning of Brooks by Judge Doro before she decided if he could represent himself. And while some of the questions seemed repetitive and it was a long hearing, he clearly agreed to what he was getting himself into.
After the judge removed Brooks, he was in that separate room. We could see him gesturing wildly at the monitor where the judge was talking to the state, but he was not let back in at that time.
It's been interruption after interruption all day from Darrell Brooks in the courtroom. He's now participating in jury selection from a separate room where he's hiding his face from potential jurors.
Are you serious? This fool.
He is, by his conduct, not the choice of the court.
No, that is judicial misconduct of anything, Your Honor. I simply merely
going to
asked
be in the
for
other
questions to defense.
courtroom for jury selection. You can take him back there.
There were over 300 potential jurors, and Brooks wanted to strike all of them. Let's listen into what Brooks was fussing about when he was over in the other courtroom.
This is ridiculous, man. So as soon as I raise the issue, I'm being disruptive. I'm intentionally trying to be disruptive. I'm intentionally doing this. I'm intentionally doing that. So I should have just stayed over here, which ain't even legal to do anyway. Can't be present and not present when it should be a motion. This is ridiculous, man. This is ridiculous. You're forcing somebody to agree to something that they ain't agree to. Y'all come up with anything y'all can. Anything y'all can. You could have left that over there. I'm going back over here anyway. Just in case. If I'm right here in front of her face, I don't have no problem hearing it. That's why he's going to, I'm going to have to go.
Jury selection is moving along for day 2.
Now, today it should be noted that compared to day 1 of the trial, which Mr. Brooks was quite disrupted, he has been more cooperative. He has asked some polite questions of jurors in response to questionnaires as well, taking part a bit more in this selection process. That being said, he started the day being removed from court, and he was let back in, but at this point, he never really lasts more than a few minutes in front of the judge before the situation breaks down and he's thrown out once again.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet to verify anything.
You
by
can take
sworn
him back to
affidavit.
the other room. He's been disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies
You
and
haven't
gentlemen.
even
We'll
honored-
have
you haven't
to
even
clear
done
the
that.
courtroom.
I don't agree to it. Stop.
And remember the times we saw Brooks take court paperwork and toss it on the floor or in the trash bin? Well, he was also doing that during jury selection.
Darrell Brooks ripped up his jury chart and multiple times refused to come back into the main courtroom. He also refused to go back to his jail cell to retrieve a list of potential witnesses that he intends to call at trial. Brooks told Darrell that he wants to call the state of Wisconsin as a witness. Darrell told him he can't do that.
He's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned once again, if you continue with that, you will be removed from the courtroom.
Remove me.
Requesting to go to the other courtroom?
Remove me. I told you that before I even came over here.
The press advised that one of Brooks' outbursts happened when a large group of potential jurors were walking past his desk. He also requested his case be dismissed, but it was unsuccessful.
Court was finally able to move forward toward preemptory strikes, that final check mark in the jury selection process, if you will, by 4:30. From a pool of 36 jurors, each side strikes 10, leaving the court with a jury of 12 and 4 alternates. The state picks first. The process is supposed to alternate from there. Instead, Brooks crossed off every juror, which is in line with his motion that every juror should be struck for cause. So the clerk of courts drew 8 of Brooks's 10 strikes at random. He eventually picked the last 2. Now the court, again, has impaneled its jury for this trial, but not without controversy throughout the day.
Mr. Brooks, are you requesting?
It was pointless of me to come over here. You can smile all you want to think it's funny. I don't take this as a joke. I don't take this as a game.
My preference is for you to be here.
On day 2 of jury selection, District Attorney Opper filed a motion to not allow the faces of the victims or witnesses be photographed or recorded. As we now know, they compromised a bit on this. We could barely see the gallery during the entire trial, and we never saw any video or photographs of the children via the court. The victims were also given the option to not be shown on camera during their victim impact statements.
I can tell from his demeanor right now, he's doing a clapping type motion. He's doing it once again. It's a clear indication that he can hear this court. I've also confirmed with the bailiff and court staff that he's able to see and hear.
The judge, Jennifer Duro, asked for a list of potential witnesses that Brooks intends to call to trial. This was how he responded.
Tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
The list that you have in your cell?
How am I supposed to do that without the list?
I'm telling you, I'm giving you the opportunity to go get that.
I'm not going to go do that.
Mr. Brooks, I'm not going to play games with you.
Brooks said he will not call his mother to the stand. His public defenders had wanted to call her as a witness. Brooks said he wants to call the state of Wisconsin as a witness.
Although we are not certain of their ages, the jury was comprised of 10 men and 6 women. All 16 were white. The following is a small portion that Law and Crime posted during the jury selection process.
With the Secretary of State.
I provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I am not.
I realize it may very well be related to your claim to be a sovereign citizen and disputing the
claim to be sovereign. That's correct.
Jurisdiction of this court, but these are not questions this court is obligated to answer.
I would like to correct the record and say that I am sovereign.
All right, you believe you're sovereign. The record is corrected. So, Mr. Brooks, we're getting really close for you crossing the line.
Really close to crossing the line.
Being removed from the courtroom for continued interruptions.
I
want you here.
To that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning. It is only, it's 8:57. I want you to be here. Certainly my preference is for you to be here to participate fully, but you do not have the right to disrupt the proper administration. I demand dignity, order, and decorum. You have been provided with the copy of SCR Chapter 62. that lists the responsibilities that myself, the attorneys in this courtroom, the litigants, it even applies, as you can see if you read it, applies to witnesses, jurors, those in attendance. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in front
Mr.
of
Brooks,
you.
I'm going to continue with a finding right now that you have flagrantly disregarded elementary standards of proper conduct. That conduct will not be tolerated. You stating things even in a mild manner tone of voice doesn't change the fact that we've had a dozen or more interruptions by you and by you alone. When you don't like the answer I give, even if that's a non-response, you continue to ask the same question over and over. You repeat yourself. You show absolutely no respect for the court, for these proceedings. You have demonstrated in the short, not even 30 minutes that we've been on the record, that you will continue to disrupt. I am going to have the jurors brought in. Again, it is my sincere hope that you follow these simple and basic rules, but the next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law. I don't give my consent.
We have the jurors here?
And I will not agree to anything.
Not yet, okay.
So again,
Your Honor, just from the
with that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of Your Honor numerous times at this point, can that title name please direct the prosecutor to answer whether there are any more charges? Can the title name please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks,
in her possession?
no one's going to be answering these questions, okay? I'm not requiring the state to do that. I'm advising you to stop asking those questions. It will be considered an he's interrupted. Take him to the next courtroom. I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
Or agree to a estoppel, and I will move the court again.
Currently, you are not muted. All right, Mr. Brooks. All right, you can mute him. All right, Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning. I understand that you object. Your objection is noted. Your lack of consent is noted. As I indicated earlier, I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions that I told him I would not answer. And even though I made a decision not to answer questions, he keeps asking those. From my perspective, they are questions that any sovereign or sovereign citizen tends to ask regarding my name, my oath, jurisdiction, things of that nature. This court, of course, has authority from the Constitution of the state of Wisconsin, the statutes. I've been duly elected twice now by the citizens of Waukesha County to preside over criminal and other cases in the courts of Waukesha County. I fully am aware that Mr. Brooks, as a sovereign, disputes the validity of that, but from my perspective, they are not issues that need to be debated. He raises these issues really just by simple statements. He has never filed an appropriate motion. Motions are governed by state law. Written motions require that the specific relief be requested, that the motion be based on law and fact. I have never gotten anything even close to that from Mr. Brooks. Even if I were to accept an oral motion, which can be proper at times, he has failed to follow the simplest of procedural requirements. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction, he's yelling what, I can't hear him, but it appears that he is yelling. I muted him because of his interruptions of the court, and I understand he objects. His objection is again once is noted. And because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. I have the ability to mute, to unmute. I can see him. He can see the 4 cameras in this courtroom right now. That would be me. It would be the table where I would like him to be seated. That is empty, the prosecution table, and then the witness stand. I am cognizant that the one limitation is the cameras do not pick up the jurors when they sit. There may be, depending on the angle on the witness stand, a few jurors that would get captured, but of course he cannot see those. He's able to hear them, of course. I will instruct the bailiffs over there to give him a pad of paper if he doesn't have one already. I know he had some documents and some things in front of him. At one point I saw him sort of do a sweeping motion and things seemed to go flying. I'll get some verification of that from the bailiffs who are over there through the bailiff that is in my courtroom. But he will at least be given a notepad, a writing utensil. He is advised that should he want to raise a strike for cause of any juror, my procedure is to address that at the end. Certainly if something comes up before that and he wishes to do that under the law, he can simply write on the pad of paper he has cause, hold it up, and I'll make a determination if I should excuse the jury and then take up that decision. I'm probably not going to do that with frequency. He would need to further not only do that, but write on a piece of paper the juror number, the basis for that request before I would require the jurors to be excused to take it up. But that's the procedure that this court will follow. Just like I did yesterday, after I get through all of the jurors to take up the issue of strikes for cause. I've been advised that Mr. Brooks did throw some items on the floor, but he does have his paperwork and a pen.
Your Honor.
Go ahead.
I just want to make sure that we put on the record that it has been verified that Mr. Brooks can hear this court.
We'll do that, yeah.
Also that I believe I had heard that the juror questionnaires for the next set of jurors coming in have been provided to Mr. Brooks.
Thank you for that reminder. He has been provided with 2 additional binders. He probably doesn't even have the first one anymore because the first binder only went to juror number 41. He does? He still has it? Okay, so he has that binder. He has 2 additional binders, which are separated. I believe it's 42 to 70 and then 71 to 100 something. But it is the balance of the jurors who had been instructed to come on day 1. This is the jurors who were not questioned yesterday. It's not even all of them who will be coming in because of the physical limitations in this courtroom. We'll bring in 41. So he has been provided with those binders. Were we able to verify? We were able to verify the audio is working. The video is working, just like we can see him, he can see us. For those of you who are in the courtroom, what he would be seeing on the monitors would be that 4 square as well, because it is through the Zoom. He would have his picture as well, so he would see the double image, if you will. I should also make a record that there are a number of individuals on my Zoom as well. There was a request by the state to allow victims under the statute and Constitution to be present by Zoom for jury selection due to the court not streaming jury selection. I believe I also have Attorney Anna Keys also watching as well, along with at least one actually I think I see 2 victim witness workers. So I have a lot of screens up here, a lot of boxes on my screen. So I believe the state has complied with victim rights. Would you please confirm that?
We have.
Did I overlook anything you asked me to cover?
Your Honor, the only other thing, and I think the court somewhat made a record by your findings, but I know that the defendant made 2 motions to dismiss for judicial misconduct. Again, I'd ask the court to summarily deny those motions based upon lack of merit, and he didn't provide any support for either motion.
I believe he did raise a motion to dismiss based on judicial misconduct. I think he also threw in there another request to stay the proceedings or file an interlocutory appeal. While that's really not something I would need to address because nothing's been filed as it relates to a request for an appeal, I will deny that summarily. There's been no basis in law or fact provided. I'll also deny the motion to dismiss based on judicial conduct, based upon there being no showing in law or fact. All right, anything else then before the jurors are brought in?
No, Your Honor, thank you.
I will, just like I did yesterday, advise the jurors that Mr. Brooks is appearing from a remote location and that should not influence their verdict in any way. It appears to me that Mr. Brooks continues to stand, make hand gestures, and talk. I will, again, just advise him, should he desire to raise any issues with the court, he is advised to write that down on paper. The bailiffs are instructed to promptly provide that either to the court staff that's in there or another bailiff, and that will be provided to me forthwith so that I can raise any issues of merit. All right, with that, then we will begin the jury selection process. And
a little flashback for you there. All right, let's get to this pre-sentencing hearing. It's sort of electrifying.
Court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
State by Leslie Basie and Zach Wichow.
Sir, please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept the value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and state for the record that I do not identify by the name stated.
The record should reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is appearing in jail attire today. The court is here to address a couple of things. Of course, the scheduling of sentencing. I also want to address a letter that was sent to the parties late last week on the 28th regarding the unsealing of search warrants, a filing from Mr. Brooks, and then an issue just as it relates to the record and the use of restraints during the trial, given a statement that was made by Mr. Brooks when the jury was coming out after they had reached their verdicts. So I'll start with the search warrant issue. The parties should have received the letter dated October 28th, advising the parties that the court will be unsealing all of the search warrants tomorrow, November 1st, unless there's an objection that is raised. Of course, that's based in law and fact. And I indicated in that letter we would address any objections at this hearing. So I'll start with the state. Do you have any objection to that?
No, Your Honor.
All right, Mr. Brooks?
I have not received anything. I'm quite sure, or I don't know if you knew, but the very second that I left your courtroom Wednesday, Your Honor, I was placed on watch. I was told that it was per jail administration, that it was policy. It was nothing I could do about it. They immediately took me right from court, stripped my cell. I talked to mental health. They changed me right over into the smock, and I was basically placed on that. They just gave me regular clothes maybe 10 minutes before I came to your courtroom, Your Honor. So I haven't. I wasn't allowed any
mail. We'll give it to you.
Huh?
I had the letter printed off, and we'll give it to you now so you can take a moment to review it. It really says everything that I just put on the record just now as well.
I accept for value and return for value this document.
I would just note there's a typo in your name, so my apologies for that. Middle initials indicated wrong. But it does reference this case number.
When was this letter? Because like I said, I've been on watch, so I haven't been able to obtain any mail whatsoever. Not from the courts, not personal mail, not anything.
So that was signed on Friday and then sent over. I'm not sure if it was emailed or if it was just delivered to the jail. I don't know if Madam Clerk has any information. It was done by my other clerk. But in any event, you have it before you. What I can tell you, sir, is that normally search warrants may be sealed for a period of time. All of these warrants were set to be unsealed previously, but due to the pretrial publicity and the various orders related to the jury, including the use of the jury questionnaire, I had, at the request of the parties and with the consent of all parties, sealed or continued the seal on all of these documents, and the previous order indicated that everything would be unsealed either November 30th or at the conclusion of the jury trial, whichever came first. Of course, the jury trial is now concluded, even though the case hasn't gone to sentencing. So my intent would be to unseal everything tomorrow, unless you have an objection and it's based in law.
I have, like you said, this is I didn't even know that this was even sent over to the jail until right now, until you told me.
Understood. Do you have an objection to what I propose to do, sir?
I don't even understand. What do you mean by sealed and unsealed? I don't.
It would become a matter of the public record, and anyone could review those search warrants if they make a request.
Search warrants for what, property?
There's a number of search warrants that have been sealed as it relates to this case.
From what I saw, everything's been pretty much public. I don't see why they need to be unsealed at this point. Everything's pretty much been public already.
All right, well, I am going to unseal them effective tomorrow. The clerk's office is instructed that first thing tomorrow morning they may unseal all of the search warrants in this case. The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. The parties will recall the tables look a little different now because there are no table skirts on them. On all defense tables in the secure courtroom, there is a ring. It's really more looks like a rectangle that is attached to the leg of the table, and an inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard, and then it's attached to the table so that it confines the inmate to a small area with that table. Obviously, during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public, and that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
why would that?
The record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So,
well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
there was no shock device.
It
on
was
your
a
ankle,
shock
sir.
device. I was told it was a shock device.
Mr. Brooks.
And
that's
it was
why
covered
I'm
up.
making the record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your characterization
I respect your
of
ruling,
those
but it
as
should be
black.
it should be noted.
Your
it should be
objection is
noted.
noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It is not fact, sir.
It is a fact. I'm the one that had them on my ankles.
Unfortunately, if there was, they never zapped your ass.
I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed?
Okay, let's take a poll. Who believes there was a shock device on his ankle restraints?
The public doesn't deserve. The public deserves to know.
You've made a record.
The public
it's
deserves
noted.
to know about
And
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this voltage.
It's absolutely false that you
That
had a
is
shock
not
device
false,
on,
and
sir.
you know that is not false.
Well, I have the photographs.
Well, show
that
the
will be part
where's the
of the
photographs?
record,
Where's the photographs?
and they
You
will
just
be
said they would be sealed. Why do they need
from
to be
public
sealed?
view.
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today,
It-
but I need to move
I don't
on
want
to
to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown. That's
not
why I
right
had
at
a
all.
chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair
and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
It's not that I don't think such a device exists. It's just that we are talking about Darrell here. Number one, he lies about everything. And number two, as much of a ruckus he created during this entire process, don't you think they'd have used it on him?
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your characterization.
It's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need to move on to
There's
scheduling.
public in the courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason why.
advising you.
And I always had the chair right here. Everybody that came in this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why did I have a black cloth
any
in front of
further
the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold
letting
me in
move
contempt.
on
That's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other courtroom.
Remove me then.
All right,
Remove
Attorney
me
Basie.
It's not going to stop the fact that they need
All right,
to know that the shock device
he's
is on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll make the
That's
appropriate
fine.
findings.
Tell the truth, though, Your Honor. Tell the truth. I had a shackle.
Lieutenant.
I had a shock device
Captain,
on my
can I
ankles.
please see you? We're off the record.
Of course, it was just another ploy for him to delay and attempt to add merit to his upcoming appeal.
The record and State versus Brooks appearances are as they were before. Mr. Brooks, if you interrupt me, I will mute you so that I can make an adequate record regarding.
You're gonna mute me anyway, Your Honor.
All right, he
You're gonna
interrupted.
mute
I
me
will mute
anyway.
him. I need to make a record of his removal. The court did warn Mr. Brooks repeatedly that if he continued to be disruptive, the court would remove him to the other courtroom. It was my sincere hope that that would not need to take place today. I gave him the final warning, and then I indicated I would be turning to the state to ask them some questions, and if he interrupted that process, he would be removed. He immediately interrupted that, and so the courtroom was closed. He was put into the other courtroom. I have confirmed that the audio and visual technology is working.
The Shocklets are turned on. Just kidding, Your Honor.
He can hear, he can see, at least the other individuals in there confirmed that that was the case. He was audible for a little bit when I first went on the record, but he continued to be disruptive, and so I did utilize the mute function of the technology so that I could make an adequate record. Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen that his conduct was did disregard the elementary standards of proper conduct, of decorum and courtesy. He was disruptive. He interrupted multiple times and challenged this court when this court was making a record regarding the restraints that were utilized throughout this trial. I'm not going to do it today, but I will at a later point in time. Perhaps after scheduling, I will have a deputy testify regarding the restraints that were utilized so that there is a full and complete record about what was utilized and what was not utilized throughout this trial. It is absolutely false that a stun belt of any kind was used on Mr. Brooks. I don't know if he's receiving that information from other inmates. But that was not utilized in this case. It was a soft leg restraint setup, if you will, where he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the table, and it is absolutely true that there was a black table skirt on the tables, both the state's table, the defense table, in this courtroom. Despite Mr. Brooks believing that it was not done for his benefit. It was to shield that information from the jury. It's also true that at all times when he has been brought into court, it's been before the court has been open to the public. If this court needed to remove him to the other courtroom, it was also done with the courtroom closed to the public. That was, of course, a security decision made by the sheriff's department. They are in charge of his security as well as the court's security during any court proceeding in this courthouse. And it was their discretion and decision on what restraints would be utilized. And again, I'll go through that later and have a record made of what was utilized, including having one of the deputies identify what's on the exhibit. I'm not going to show that publicly. Again, there are security reasons. We don't, frankly, need inmates doing research or the public doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view so that their protocols and practices have that, frankly, veil of secrecy. It's important given the security issues. It's a law enforcement function, and that is my decision on that. As far as Mr. Brooks being in the other courtroom, again, I did that pursuant to the authority found in Illinois versus Allen. I did not hold him in contempt. Frankly, because it's a scheduling type hearing, I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the other courtroom. With that, I am going to address scheduling. I will be asking each party in turn how much time they believe they need to present their various sentencing remarks and whether anyone will be speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like to either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom as they come in to speak, because we can't fit everyone in the courtroom at one time. So we'll need to get one set in, get another one to room 115 so that they can hear what's being said. So we're thinking 4 hours, and speaking with the families and the victims Wednesday after the verdict. I think there's a strong desire to have the sentencing before the anniversary of the parade incident, and that obviously is November 21st. In checking with people, November 15th, 16th works for everyone. Specifically, the 16th works for everyone that would like to talk. I know that this court obviously has court calendars. I do have other dates that would work. Unfortunately, those go out to the end of December, end of November, beginning of December. But again, I can't emphasize enough, there are a lot of families who are leaving town the week of the parade, and I think the general consensus would be it would be nice for them to have some finality to this before they leave so that they're not around here at the time that a loved one was injured or killed.
By any chance, did you have an opportunity to look at my calendar and some of the jury trials and talk with your colleagues? I mean, one of the cases, for example, I have on the 15th is an attempted homicide trial. I don't know if that's going to go or not, but just like this court gave due attention to this case, I need to be mindful that that case has been scheduled since June.
I did not. I received these dates, although I believe that they were probably sent this weekend. I did not check my email over the weekend, so I did receive them this morning, and unfortunately I did not take the time to do that. We can certainly look right now. Do you know who's handling that attempted homicide from our office?
I believe that's Attorney Sitzberger.
Okay.
There's other cases as well, because it's rare that I wouldn't stack trials, and so there's also another serious felony matter with Attorney Thurston for your office. That one was scheduled in August. I have another one with you, yes. Attorney Basie. I'm just looking at the number of, I have 8 different defendants, many more cases, but 8 different defendants scheduled for jury trial on the 15th. The other thing is on the 16th, our CJCC has a very special meeting. I'm still the chair of that, and that is an anniversary of the CJCC that I do not want to miss. So not that I couldn't work around that, and it's not that I'm not willing to change, my calendar in any way that I can.
I can tell you, Attorney Witchow did reach out to Attorney Sitzberger. He indicated, and he said we could put this on the record, he's 98% confident that that will resolve, the attempted homicide will resolve. Attorney Thurston is not in the office today, so I can't speak to that trial.
All right, let me, before we look at dates, of course, let me talk with Mr. Brooks and find out how long he anticipates his sentencing remarks and whether anyone. So, sir, I have unmuted you. If you could speak to scheduling.
First, Your Honor, I would just like to say that I know you're well aware that I have ongoing matters in Milwaukee pending too. I have to be in court there in 2 weeks, and those cases are scheduled for trial as well.
Ongoing matters. You mean charges for more illegal activity?
I haven't had the opportunity to speak with my representation over there because of the protocol that I've been on these past, I think it was 5 days since I last was in your court. I would like the opportunity to, now that obviously this was the big case, obviously, if it pleases the court, if it pleases Your Honor, I would at least like to get a disposition on what might happen there. I go to court there in 2 weeks. I'm sure that I would learn a lot more at that time. I'm not sure if I'm going to have the same representation at this point or if something's going to change with that.
Do you know the specific date that you're scheduled?
The 17th. That's for both cases. I don't know why they put both cases on the same date. And like I said, I don't know if anything's going to change between now and then. But both of those cases are scheduled to go to trial. And like I said, with the representation there, I don't know what's going to happen with that as of yet. There's been issues for months with that. I know that's something that Milwaukee has to deal with and not your court. But it would be a great help to me to at least be able to find out what I can find out about what can possibly happen there, and to also do any work that I may need to do on my end to prepare for that.
So I have looked at the dates. You are right. There's a hearing on the 17th at 2 p.m. The trial, though, in that case is not scheduled until December 12th. So my belief would be I could certainly see the judge in that case understanding if we had to go to sentencing, or I chose to go to sentencing on those dates. And it looks like, again, both cases are scheduled for those same dates.
Yeah, it was kind of weird to me. The way they scheduled both cases on the same day was just kind of like, I didn't really understand why they did it like that.
Well, let's talk about a related issue, and that is, do you anticipate anyone speaking on your behalf at the time of sentencing?
I do.
All right.
I do.
And do you know how many people you anticipate speaking on your behalf?
I don't know an exact number, Your Honor. Rough estimate, there'd be 20 or more. I have not yet spoken with everybody, obviously, because of the protocol that I've been on. I haven't had the chance to, essentially, some people will be traveling to Wisconsin from different areas, different states. And I know they've expressed wanting to be there to speak for that. But like I said, me, myself, not being able to have the opportunity to speak with them personally, I don't know exactly how many, and I don't know how many people will be coming from different parts of the states. I would ask, if it pleases Your Honor, to be able to have everyone that does want to speak and does want to address the court, to give them the opportunity to be here for that. I know there's, as far as the people that are here in Wisconsin that will speak, one thing that they was stressed to me is that how is everything going to affect what's going on in Milwaukee? So that was like one thing that came up, and because I had totally forgot that the Milwaukee court dates were this close. And so I was just like, yeah, you're right, 17th, that's 2 weeks roughly. I don't know exactly where we're at in those proceedings. Like I said, there's still like some issues going on with the representation. I haven't been able to reach out. Obviously, I can't reach out from where I'm at, collect call wise. And I've had very, very limited interaction with the current representation in those matters. So I don't know what pleases you, Your Honor. I don't know what pleases the court, but I guess what I'm seeking is for enough time to know exactly who's going to be speaking, where they're going to be traveling from, and a little bit more information that I can provide to this court about the proceedings in Milwaukee County.
One of the things that I've done for other cases, and I know I was asked about this previously as well, and I would also offer it up to the parties, is I will also make available Zoom for victims, family members, including your family members, who would like to make a statement on your behalf. The only thing I ask, though, is I'm not just going to open up my Zoom to anybody. And so anyone who wants a relative, a victim, family member to speak, whether it be from the state or from you, Mr. Brooks, is I need to know who, no later than probably a couple of days before. I'm leaning toward scheduling this on the 15th, so that would be like the Friday before, which would be the 11th, so that when they come on the Zoom, they're identified, and then I let them in. So I understand your concern about the Milwaukee, but if I hold this on the 15th and the 16th, by your description of how many people, by what the state said, I think it's going to take about a day to hear the remarks from the parties, and then I would come fresh the next day to give the court's sentencing. And so probably a day and a half, but I'd set aside both of those days just to be on the safe side in case it takes a little bit longer for either of the parties to present their sentencing remarks.
Your Honor, I'm not interrupting.
Go ahead. Go ahead.
I was trying to make sure I didn't interrupt you.
Go ahead.
Your Honor, with all due respect, if it pleases the court, if it pleases your court, Your Honor, because of my situation, I could benefit from a little bit more time. I'm not asking for something outrageous here. Just enough that I can tie up some of my loose ends, get you the information that you need to be able, if someone has to be present by Zoom or whatever the case may be, or to find out if these people are actually going to travel, and also still be able to prepare for what I need to prepare for, because obviously I still, regardless to anything, I still have to be prepared to continue court proceedings I still have to be prepared. It will really, really be a big help and a great benefit if I can have just a little bit more time to tie up the loose ends and get everything done in a timely fashion to be able to be ready to go and present what's needed to the court.
I understand that, sir. The issue the court has is, obviously, if I wait much longer than that, I would, out of respect for the victims, avoid the week of November 21st. That's also Thanksgiving week. I don't think that would be an appropriate time for sentencing. But then after that, I do have, my calendar is just incredibly full. I have some time off in there. I have trials almost every week other than the week that I'm off, all the way up through the week of December 19th. And then again, I'm off again for the holidays. And so that puts us into January, and I'm not willing to do that. And plus I need to avoid the week of that trial in case one of your cases goes to trial. So I think I'm giving the parties ample time. I'm giving alternate ways for family members to speak, and that is by Zoom or in person, should they wish to be here in person. And I'm willing to clear my calendar even of those trials. Hopefully my trials resolve, but to the extent that they don't, then I will clear Tuesday the 15th. Wednesday the 16th, though, I would not start until later that day, given the meeting I have to chair for the Criminal Justice Coordinating Council, or Collaborating Council. So that's from 8:30 to 10. I need to talk with our executive director a little bit more because I know we have a special type of meeting schedule, and I don't know if it will go longer. At a minimum, it would be safe to say the afternoon on that date. And no matter what, that would still clear Mr. Brooks to be in Milwaukee on the 17th. We're one county over. It's not unusual to do an order to produce that close.
I'm sorry.
No, so I am going to schedule it for the 15th and the 16th. The 15th will start at 8:30 a.m. And depending on, I'll be ready to go no matter what on the 15th. And if the state takes into the afternoon and then Mr. Brooks needs the rest of that afternoon or into the next day, I will certainly make those accommodations. I think I'm going to tentatively say we're going to schedule it for 1 p.m. on the 16th. And if anything changes, I'll let the parties know. And then I just need to know by Friday the 11th at noon who the parties are asking make their statements by Zoom with a listing of their names so that when they appear on the Zoom, because then I'll approve it, we'll release the Zoom information. I need everyone to be aware, though, including victims, your family members, and it may not just simply give this Zoom information out. It will be only for those individuals that are identified by the state as wanting to appear by Zoom. I want to keep a tight control over that. And if I don't see a name either says a name that's been approved, let's say you had a friend by the name of John Smith. If John Smith doesn't say put on their Zoom info John Smith, and it's just a phone number, I may not let them in. They have to be identified, can't just give it out to anyone. And it's only for those individuals who want to make a statement, since the proceedings will be live streamed as well, whether that be how we've been doing it throughout the trial or if I utilize the Zoom and the live stream I've done in the past, so that other people can watch it as well and to facilitate the smaller courtroom that we have. So that's my decision on that. And I want to just very briefly have, I believe it's going to be Deputy Kibler who's going to testify about the restraints.
Your Honor.
Yes.
But I'm not trying to interrupt.
Go ahead.
You said, when is this supposed to be? Because I'm definitely going to need a little bit more time than the 11th.
Mr. Brooks, I've made my decision. The sentencing will be on the 15th and the 16th of November. Anyone who wants to appear by Zoom on your behalf, you must file a request in writing no later than noon on the 11th. The same is true for the state. Everyone needs to be specifically identified so that I can make the appropriate approvals, and only those individuals who I specifically approve to appear by Zoom may be on the Zoom. The Zoom information can't be passed out further. And I'll create a special Zoom for that, and I'll make sure that I work with Teresa to do that and get that information when I approve that to the parties.
Your Honor, what if I'm placed on the protocol per the jail? What if?
Mr. Brooks, that's between you and the jail at this point. If there is something you need to first go through them. I'm not going to step on their toes with their protocols. I'm sure they'll understand this is a very important sentencing for you and make certain accommodations. They've done that throughout this case. I trust that they will do that as they determine is appropriate.
They haven't done it for the past week when I went on a protocol without even telling them anything suicidal in nature, and I was still placed on a suicide watch protocol.
I understand that, sir. I need to move on because I do have calendar this afternoon, but I want to have Detective Kibler come to the stand. Kibler.
Your Honor.
Deputy, what did I say? Detective, did I give you a promotion? Sorry. All right. He's going to come on up to the witness stand. I'm going to swear him in, and we'll go from there.
For the record, may I respectfully object to your ruling, Your Honor?
It's noted for the record. All right. Madam Clerk, swear him in, please.
For the record, may I respectfully request a legal reconsideration
All right,
of your
Mr.
ruling,
Brooks,
Your
I'm going
Honor?
to have to mute you because I need to keep going and I can't have this disruption. Go ahead. Raise your right hand.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Thank you, sir. Have a seat. I'll let you put your name on the record so I don't get that wrong. And so go ahead. Please state and spell your first and last names.
First name Nicholas, Nicholas. Last name Kibler, Kibler.
All right, thank you. And you are employed in what capacity with the Sheriff's Department?
I'm a deputy for the Waukesha County Sheriff's Department.
You don't have a meeting. All right, sir, were you assigned to the trial of Darrell Brooks?
I was.
And can you tell us in what capacity?
My capacity was, specifically, my responsibility was Darrell Brooks, along with Deputy Stengelson.
And were you in court at the start of the trial on October 3rd?
I was.
And did you come into court or work the court trial every day that we were in session?
I did.
And can you, were you at all in charge of the restraints? Let me ask you this way. Do you have knowledge of the restraints that were utilized on Mr. Brooks throughout this trial? Can you describe those, please?
It's a soft restraint that we used. It was not any type of electronic control device. It was just a soft restraint that we applied to Mr. Brooks prior to coming into court every day.
And would that be a restraint system that was on his legs or something else?
It was around his ankles.
All right. Throughout the trial, the tables in this courtroom had black table skirts. Do you remember seeing those?
I do.
And did that hide from view in any way the use of the restraints from the jury?
It did.
And were the restraints also attached to the table in some fashion?
They were attached to the table by a tether.
At any point in time, were there any other restraints utilized in the courtroom?
There was not.
At any point in time, were there any type of electronic or stun device placed on Mr. Brooks?
There was not.
Anything you would want to add to the record regarding the restraints that were used in this case, sir?
Not at this time.
State have any questions?
Just briefly, Your Honor. Sir, you indicated that the restraints were connected to the table through a tether, is that correct?
Correct, and then we would secure them with a padlock.
And how long was that tether?
The tether that was in here was 4 feet.
So Mr. Brooks could stand up?
Correct.
He could walk to his left briefly and walk to his right, is that correct?
That's correct.
And that was the same rule that the state had, that we had to stand up and use our table to question witnesses. That was the same rule that applied to Mr. Brooks?
Correct.
Okay, nothing further.
Mr. Brooks, you're muted. Do you have any questions regarding the restraint system as testified to by Deputy Kimber?
Yes, I do. And Your Honor, you can't practice law from the bench.
Your question, sir?
So none of your fellow deputies told me that it was a shock device when I asked what was being placed on my ankles at the start of this trial?
Not that I'm aware of.
Not that you're aware of? Do you know for sure that I was told that they were a shock device?
I don't believe that's the truth. I believe every time you had those devices put on, I was in there, and it was either myself or Deputy Stenielson putting them on, and I did not tell you that, nor did I ever hear Deputy Stenielson tell you that they were an electronic device.
So you were here every single day for every single moment of the trial?
Correct.
And you never heard any deputy tell me that they were, matter of fact, let me back up. Do you recall me asking what was being placed on my ankles?
That I don't. If you did, we would have told you it was just an ankle restraint.
And you said that it was an ankle restraint. Did it have any metal parts?
Yes.
And what are those metal parts?
Metal part is where a strap went through and the locking device.
And what are those particularly, let's say if a defendant in a trial attempts to, let's say, attack someone, what would be the purpose of those ankle restraints?
The restraints we had on you would limit your movement, so if you did try to do anything, we would have had enough time to control you.
And you state that, well, the prosecutors stated that the same rules were in effect for the defendant as the prosecution, but were they not allowed to put up exhibits to go to the front of the courtroom and put up exhibits?
They might have a few times, but
The record will reflect it was one time in the presence of the jury, and after that I called them on it and said that would not happen. And then after that, it was only with the permission of the court and then outside the presence of the jury.
I don't believe that, Your Honor, you can practice law from the bench and answer the question that was asked to the...
Mr. Brooks, I'm in charge of the record, not you, and the record's going to be accurate.
I didn't say, well, it's not accurate. You're practicing law from the bench.
All right, Mr. Brooks, do you have any other questions for this witness?
Yes, I do. Yes, I do.
It has to be about the restraint system. Please continue.
And was I allowed to approach the bench and put up exhibits at any time during this trial?
You were not.
And so, how is it that the prosecution was able to do something that I was not able to do?
That's not for me to answer.
It's because of the shock device that was put on my ankles, correct?
There was no shock device on your ankles, sir.
I was told that it was. And you said that you don't recall hearing that being told to me, correct?
No, it was not told to you by me.
Yeah, by you, but you also said that's the point that I'm getting at. I'm asking the question. You said that it wasn't told to me by you. I never asked you, correct?
You never asked me, but I also did not ever hear Deputy Stenielson tell you that they were a shock device.
I never asked you. I never asked you, yes or no?
No, you did not.
So do you know for sure if I ever asked any other deputies?
Well, considering I was in there when the restraints were being placed on you, I did not ever hear anybody while I was inside the bullpen while they were putting restraints on you.
So it'd be fair to say that you don't know for sure if I ever asked what the device was that was being placed on my ankles?
No, I can't be for sure.
So how do you know I didn't ask?
You don't have to answer that. That's argumentative.
I mean,
All right, the record's been
I'll
made. Mr. Brooks, I'm cutting off the questioning. I'm just muting him for a moment. The record's been made. Deputy, you may step down. Mr. Brooks, if you have additional information that you want to provide to the court, I'd ask that you do so in writing, and you provide the identity of any and all individuals you claim provided you with information that you were in a shock restraint. But I'll make a finding based upon the testimony of Deputy Kibler and also my knowledge of being in the courtroom every day and seeing Mr. Brooks being attached, meaning they would secure him to the table, they would unsecure him when he needed to move and other things. I'll make a finding that the soft restraint system was what was utilized, and at no time was he ever in a shock type of device. All right, with that then, ladies and gentlemen, it is going to conclude the hearing today. We have the sentencing dates. I would also ask that any and all written material that either side wants this court to consider also be filed by the 11th by noon. So that's November 11th at noon. That will give this court ample time to review it ahead of the hearing on Tuesday, November 15th. All right, thank you everyone. We are in recess. The court's going to take a short break before I start with my remaining afternoon calendar.
Every lie he tells, he gets caught in it. He's great at coming up with them on the fly, but he doesn't think too far past that initial moment. Okay, now we move on to another moment he tried to fib his way around. After the verdict, but before the sentencing, I posted a video about Brooks and the media. Here's a clip I think y'all will get a kick out of.
Apparently, the New York Post visited Brooks in his jail cell. This happened, this was published on November 19th. A madman who's been convicted of homicide of 6 people, when he plowed his car into the Waukesha Christmas parade, tried to squeeze the Post for money during a bizarre jail interview. Just 2 days before he was sentenced to 6 consecutive life terms in prison on Wednesday, Brooks hid from an iPad's camera inside his cell in the Waukesha County Jail during a video televisit with the Post. God, I wish they had this on video. I can't find it though. With Brooks out of frame, the camera showed a ranting man in an adjacent cell who stared and squinted to get a look at the reporter. "Nobody's going to talk to you, clout chaser," the man yelled. After remaining silent for 15 minutes, Brooks suddenly spoke up. In the third person, while posing as a family friend. Maybe it was Marcus. "If you want to talk to Mr. Brooks, you're going to have to send a check to Mr. Brooks," he declared. "I would have to ask him how much, but I'm sure it's going to be a pretty penny. I don't think that's fair to him to give free interviews and he's not getting compensated for it. The only thing I can say is if you want to interview, you're going to have to pay. You have a great day. God bless you," he said, before going silent for the remainder of the 25-minute video call. The Post does not pay for interviews. Later, Lieutenant Pierre Burgess from Waukesha County's jail division reviewed the video footage and confirmed that Brooks was alone. That I'm sorry, I can't. He's so stupid. He was alone in his jail cell for the duration of the call.
Oh, good times. Well, that's going to do it for this video. Join us in the next one as we enter day 1 of 2 of the sentencing process.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.